All right, well, thanks again everyone for coming. I'm gonna go and get started and officially welcome everyone to the NSNC's First Amendment Forum. For those who don't know me, I am Executive Director Steve Ost. And to tee up the night, first of all, in 45 simple, powerful words, the First Amendment of the United States Constitution asserts, quote, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of people peaceably to assemble and petition the government for redress of grievances, unquote. The Founding Fathers' intent was to create a marketplace of ideas where citizens could freely express their beliefs without reprisal. However, the reality of free speech in the United States has become far more complex. The Constitution's framers couldn't have envisioned internet trolls and active misinformation and disinformation campaigns that cloud our ability to delineate the truth. Further, the saturation of media has created a cacophony of viewpoints that make it difficult to verify the veracity of a story or statement. And what role does money play in the marketplace of ideas? How can we be sure that content we read or hear hasn't simply gained our attention because those with greater financial resources and influence have simply bought prominent positioning for their agenda? The rights to expression pledged in the First Amendment promise a great deal, but are these promises always fulfilled? In what ways is our government and our society at large falling short of meeting these goals? Tonight, we welcome several experts to discuss various facets of free speech Americans are entitled to enjoy as afforded by the First Amendment. They include Robyn Blumner, President and CEO of the Center for Inquiry, an organization that advocates for separation of church and state; Lori Duff, a municipal court judge and longtime author who will address various legal precedents and challenges that relate to free speech; Leonard, a journalist and professor who's been enmeshed in the Fourth Estate and academia for more than 30 years, who will discuss free speech challenges relevant to educational environments; and Melia, who's currently the Washington, D.C. Office Director for PEN America, an organization that advocates for writers' freedom of expression, who will address the impact a lack of quality news outlets has on rural and economically challenged communities. Our four panelists will have approximately 10 minutes to address their First Amendment focal points. And at the conclusion, we'll have about 15 minutes for questions and answers if there are any. As a quick housekeeping note, please direct your questions to the Q&A section of your Zoom screen. And please specify the panelist you'd like to respond to your question. So our guests will speak in alphabetical order: Robyn, then Lori, then Michael, and then Tom. So thanks again, everyone, for attending. And Robyn, the virtual floor, as it were, is yours.
Well, thank you, Steve. Thank you. It's a pleasure to be with you today, along with my eminent fellow panelists. And I'm going to speak today about what the founders meant by the Constitution's religion clauses and what's going on with them today. And so I don't bury my lead. Church-state separation is on life support right now, and unfortunately, the patient is not going to make it. Now, we all know how the First Amendment begins. Steve just offered that up. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. The Establishment Clause and the Free Exercise Clause were meant to be read in tandem. The founders, and in particular James Madison and Thomas Jefferson, who were the chief architects of the religion clauses, were designing a government where religion would have a role separate and distinct from government. The Establishment Clause would keep government from entangling itself with religion, either to its benefit or to its detriment. And the Free Exercise Clause would protect freedom of conscience and let people believe or not as they wished. This was a deliberate break from the model in Europe, where the crown and the church were aligned as interlocking power structures. The founders were well aware of this history and the bloody religious wars that this model engendered, particularly between Catholics and Protestants. They also knew well the way early colonists to North America treated people of other faiths. Notoriously, the Massachusetts Bay Colony did this to the Quakers. In the mid-17th century, the Puritans passed laws against Quakers, making their mere presence a capital offense. If you harbored a Quaker, if you attended a secret Quaker meeting, you would be subject to very severe penalties. For instance, for a second offense, if you're a woman, it would result in a hole being bored into your tongue. For men, an ear would be cut off. And a third offense brought hanging regardless of gender. It was against this not so very long ago history that the Establishment and Free Exercise Clauses were born. And we don't have to guess at what was meant, since Jefferson and Madison left behind rather significant writings on the subject. So most of us know about Jefferson's letter to the Danbury Baptists. It was written on New Year's Day in 1802, and President Jefferson assured the Baptists that the First Amendment had built, quote, a wall of separation between church and state. Perhaps less familiar is James Madison's memorial and remonstrance against religious assessments. This was Madison's argument against a proposal in Virginia to fund Christian ministries with taxes. And Madison wrote that religion was not something that should be forced on the people by government through a tax levy, and that providing taxpayers support to religion would end up corrupting religion. And in the end, that measure was defeated. So Madison and Jefferson were situating the United States as a secular democracy where the government does not prefer one religion over another religion. It does not prefer religion in general over no religion, and where tax money does not flow into religious coffers, which is why I find it really so distressing that the originalists, the so-called originalists that are on the Supreme Court right now, are claiming basically that the opposite is true. The conservative wing of the High Court consists of Justices Samuel Alito, Clarence Thomas, Brett Kavanaugh, Neil Gorsuch, and Chief Justice John Roberts. They are actively working against the ideals and values that were baked into the American experiment on religion. And our newly minted justice as of tonight, who will be confirmed, within minutes, Amy Coney Barrett, will add to that side of the ledger. These jurists are seeking to grant religion special and ahistorical standing under the law. They seek to excuse religious people and businesses from the laws that apply to the rest of society if those laws go against a religious sensibility. They seek to allow government to engage in sectarian religious exercises, whether that be prayer at government functions or prominent displays of sectarian symbols on government property. And most distressingly, they are demanding that taxpayers subsidize religious entities whenever government subsidizes similar non-sectarian activities. The goal of this group of justices is to do to the Establishment Clause what Grover Norquist wants to do to government, which is to shrink it down to a size where it can be drowned in the bathtub. And unlike Grover, who has no official power to do the deed, these justices have the power. They have the motivation, and they are doing it. They have rewritten Establishment Clause jurisprudence to a point where church-state separation is now considered open hostility toward religion and is therefore unconstitutional in their view. And there's no better evidence for that than a case decided last term, Espinoza versus Montana Department of Revenue. So in that case, the court declared null and void the no aid clauses that exist in 37 states. No aid clauses are also known as Blaine amendments, and they are muscular church-state separation clauses in state constitutions that specifically bar states from providing financial support to religious bodies, institutions, and schools. Well, in the Espinoza ruling, the court said a program in Montana that gave a tax credit to people who donated money for students who wanted to attend private school must also be available for students attending religious schools. Montana's application of its no aid provision to limit the scholarships to students attending non-sectarian private schools ran afoul of the Free Exercise Clause, according to the court's conservatives. It was a 5-4 ruling. In other words, no aid amendments that kept tax money out of religion, as Madison urged, are now a form of unconstitutional religious discrimination. Last term as well, the court shielded religiously affiliated entities from having to abide by anti-discrimination laws. The court expanded what's known as the Ministerial Exception, which exempts religious institutions from anti-discrimination laws when they choose their leaders. Now, this makes perfect sense when we're talking about hiring a minister, a priest, a rabbi, an imam. But the court stretched the definition of what constitutes a religious leader to include essentially all teachers at religious schools. It's a precedent that could easily be applied to people working at religiously affiliated universities and hospitals, stripping all of these employees of their important legal job protections. And looking forward, there's a case that will be argued the day after Election Day that will add to this trend of giving religious sensibilities veto power over the laws that apply to the rest of us. The case is called Fulton versus the City of Philadelphia, and it involves the foster care system in Philadelphia. The city refused to renew a contract it had with Catholic Social Services to evaluate prospective foster parents because Catholic Social Services wouldn't approve same-sex couples as foster parents. So after the contract was canceled, Catholic Social Services sued the city on the grounds that it has a First Amendment right to be paid with tax dollars and apply its own religious criteria to the provision of services. Now, if Catholic Social Services wins, and I think they will, this means that every government service that uses religiously affiliated agencies as contractors could include limits on who will be served. Homeless shelters, food banks, job training, medical services, they could refuse to serve LGBTQ clients, as well as anyone who is not of the same faith as the service provider. Now, this is not hyperbole. In South Carolina, Miracle Hill Ministries was granted a waiver by the Trump administration last year, so it could deny foster care approvals, not just to same-sex couples, but to any non-Christian couple. And they were being paid with tax dollars. So you can see it now, no Jews, Muslims, or atheists need apply. This is a recipe to end our religious peaceful coexistence. The brilliance of Thomas Jefferson and James Madison's vision brought us 200 years of religious peace in America. And a group of Christian nationalists on the Supreme Court, who ironically claim to be speaking for the founders, are in the process of blowing it up. So I just end with the sad conclusion that church-state separation is doomed for the foreseeable future.
Steve, you got a microphone.
Thanks, Robyn. We'll address questions after the panel. So next we'll turn to Lori.
Okay, well, I'm going to talk about free speech and freedom of the press, which is thankfully a little more upbeat in its outlook. I'm going to give a little bit of a historical perspective first, and then we'll get a little bit more into the current status of things, which thankfully is more or less exactly the same. It is my opinion that but for freedom of speech, there may or may not have even been a revolution if England and the representatives that England sent over here to the Americans before we were Americans had let us say what we wanted to say, given us the right to speak when we wanted to speak, we might not have had all that suppressed rage that caused us to feel the need to revolt. And one great story that I find inspirational is In 1733, there was a man named John Peter Zenger, and he owned a newspaper in New York. And he was not a big fan of the governor, whose name was William Cosby, no relation that I know of. He was an appointed by the king as the governor of New York. And he published in his paper all kinds of things that he claimed the governor had done that he was not a fan of. Well, the governor Governor Cosby did not like to read all these things about himself. And so he ordered the sheriff to have Zenger arrested, which the sheriff did. Thankfully, there was rule of law somewhat, and the grand jury took a look at the facts and said, well, you know what? Zenger really didn't commit any crimes, so you have to let him go. They just declined to indict him. Well, Cosby was still pissed off. And so he got the attorney general to sue Zenger for libel. And Zenger hired a lawyer named Andrew Hamilton, which is no relation to Alexander Hamilton. There weren't a whole lot of names back then, I guess. And they, rather than deny the charges, they had a kind of unique argument. And their argument was, heck yeah, we did it. We did it and we'll do it again. We did it because everything we said was 100% true. And because it's true, you have to let us do it. And the judge in that case listened to all the evidence, found that what Zenger had said was true. They basically proved what Zenger had said. And the ruling was that because what he said was true, it can't be libel, that truth is a defense to any kind of defamation, slander, libel. And that is a precedent that still holds true today, that if what you're saying is true, then you can say it. And it doesn't matter how hurtful it is. Truth is a defense. And that was the first time that was used, and it's still being used today. And it's great, because one of the wonderful things that the First Amendment does is it allows us, as not just as journalists, but as people, to speak truth to power without consequence. And then one of the things that makes it even more exciting, if you're a nerd like me, is that when you have public figures like the governor, like the president, like congressmen, like justices of the Supreme Court, like celebrities, anyone who is a public figure, even if you're off a little bit, you can still say it, as long as you didn't have any actual malice. And actual malice is a legal term of art that basically means as long as you didn't actively know that you weren't telling the truth, and you didn't have a real good idea that it wasn't true. And if you read anything about this, you'll run across a case called New York Times versus Sullivan, which happened in the mid-60s. And New York Times versus Sullivan was a case that occurred when some supporters of Martin Luther King Jr. took out a full-page ad in the New York Times supporting him and saying some unkind things about the police department in Montgomery, Alabama. And the police commissioner there was a guy named Sullivan. And Sullivan was none too happy about being bad-mouthed in the New York Times, and he sued the New York Times for printing this ad. The main difference between the New York Times case and Zenger's case was that the people who put the ad in didn't quite get all their facts straight. They misrepresented how many times Martin Luther King Jr. had been arrested. They got it wrong. They misdescribed the song that the protesters were singing. It wasn't the main details. It wasn't necessarily the important facts, but they got them wrong. They couldn't prove that everything they had said in this ad was correct. And so the trial court found against them because although truth is a defense to libel, they weren't accurate. So they gave Sullivan a $500,000 award, which is a lot of money now, but you can imagine how much money it was in 1965 or so. Well, the case went all the way up to the United States Supreme Court. And the United States Supreme Court, in a unanimous opinion, said, doesn't matter, that all of these people are public figures. And unless there was actual malice, unless they were deliberately trying to misrepresent the facts, they knew, they should have known, they were trying to do harm by misrepresenting these facts. The fact that these are public figures means that they have the right to say this. And in fact, not only do they have the right, it's important for them to say what they want to say. And I'm going to quote here: profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. And that was Justice Rehnquist, who was at the time one of the more conservative justices on the court, who wrote that decision. And lately, there are a lot of decisions, and you can pull up the decisions yourself if you're interested in them. Oddly enough, one of the best places to find them is Twitter, because people reference them all the time. You can just click on the links as people are posting them. Whether you are a Trump supporter or whether you dislike him, there is a lot of litigation that is engendered by his administration trying to stop the publication. It actually goes on both sides, both trying to stop the publication of certain books, magazines, that kind of thing, and also defamation suits based on what people have said. And those opinions, 100%, every single one of them, all fall in the favor of free speech, all of them. And there's some great quotes. Rhetorical, hyperbole, and opinion commentary are intended to frame a political debate, and as such are not actionable as defamation. Your opinion is your opinion. It can't be true or not true. It's your opinion. So if you're not stating something as fact, you're stating this is what I think. It doesn't matter how nasty or unkind it may be. It's your opinion. And if you're saying it because you want to start a debate, or because you think your opinion needs to be out there because someone wants to hear it or someone should hear it, more power to you. Go on. That's protected. That's in federal court. It's currently, within the past month, saying, yeah, go ahead. That's what you need to do. And that's important. And the written word especially, there was a case where the publication, and this was with it this year, there was a case where the publication of a book was they tried to stop it. And the court quoted a 1945 case about how books and magazines and all that is just, it's important when you're talking about public discourse. And they said the underlying premise of the First Amendment is that the widest possible dissemination of information from diverse and antagonistic sources is essential to the welfare of the public. And this is so important that in that case, there was an argument made that there was a contractual waiver of the First Amendment privilege. And that's basically a hush clause. You know, you can't talk about this. And the court said that even if there was, what they were talking about was so important that that contract is no good, that you couldn't even waive your right to talk about this. That's how important it is to have public discourse about this particular topic with these particular people. So people ask me all the time, because as soon as they find out I'm a lawyer, the first thing they want to ask me is how they cannot get sued in any particular situation. And the answer is you can't, because where there's a person who wants to sue somebody, there's a lawyer who's willing to try. But you can win. You can make it so that you will most likely win your lawsuit. And when you're talking about free speech, especially of a public figure, someone whose name is recognizable, it would be hard for them to sue you and win, because that is number one in the constitutional amendments. The framers thought it was so important. It was the basis of our revolution that we needed to speak, that it is so important for us to be able to speak truth to power, that the public discourse, our ability to argue and pick apart each other's arguments in order to test them, is so critical to our functioning as a nation that it's enshrined. And even now, that we need to, there's still no argument, even with left, right, center, everyone agrees this is stuff we need to talk about. And with that, I will pass it on to the next panelist.
Okay, well, thanks. Looks like you're up, Michael.
Okay, coming in from on deck to the batter's box. I did a little homework before I started this thing, and I was kind of surprised that I didn't really know this, which was that when the First Amendment was passed, well, for example, in 1791, it was interpreted as applying only to Congress shall make no law. So as long as Congress wasn't messing around with your religious freedom, your freedom of speech, your freedom of assembly, then places like schools didn't matter. In 1915, a California Court of Appeals ruled that students could be suspended for criticizing school officials. And it wasn't until 1925 the Supreme Court ruled that the First Amendment did fall under the 14th Amendment due process clause. And Judge Scalia and presumably Amy Coney Barrett would probably call that time the good old days. But it wasn't until the 40s really that the court finally came to the notion that we enjoy First Amendment rights across the board, and that primarily came about when a group of Jehovah's Witnesses sued on the grounds that saluting the flag every day in school was against their religion. Those liberal Jehovah's Witnesses prevailed. So now we're below water in 2020, and yeah, there are some topics in education that are coming from where you think they might be coming from the Trump administration. So, for example, there was an administrative executive order a month ago which said critical race theory is un-American and therefore will cut off federal funding to universities that include implicit bias or having to do with critical race theory. And that is a social philosophy that argues that societal and cultural structures are possibly more to blame for racial animus than individual or psychological factors. So there are clear First Amendment implications there, and it never went anywhere. It was just another one of those bombs that get thrown out there and then it goes away, just like a lot of things do in the Trump administration. Hang on, I just skipped ahead too far. Where are we? Okay. So yeah, then a couple years ago, an executive order threatened federal funding for universities that don't protect the First Amendment. Who doesn't protect the First Amendment? And that was really a dog whistle from the Trump administration to counteract, or to support rather, the right-wing theory that universities are indoctrinating students to be left-wing whatevers. And that didn't go anywhere either, but at least the dog whistle was there. So now I said I did my homework, and I have to give a lot of credit to the provost here at Indiana University in Bloomington. Her name's Lauren Robel, excuse me. She was the dean of the law school before she became provost, so she's got 1 foot in one pile and 1 foot in the other. So she's a good source for these things. And so we had a nice conversation. But some things are same as they ever was, so on. So typical threats that we find, particularly with student media, for example, student press doesn't have the same rights as legacy media. Student press advisors can get called on the carpet or even dismissed for championing the rights of student journalists. Student press can be just defunded. And if we didn't know, ads don't pay the freight any longer. So here at Indiana, where the great Ernie Pyle was once the student newspaper editor, I held out a lot of pride that we were still going 5 days a week with a print publication. Now it's 1. So that's where we're headed. Other topics, denial of access regarding searches for presidency or other top positions. The old, we'll keep denying it and you keep fighting us and we'll see who prevails in the end. And as you know how schools operate, you have a different staff on your student newspaper every semester. So oftentimes they can wait it out, or they force students to file FOIAs, whatnot, and just stretch things out if they don't like it because they're students. So that's always an uphill battle. They ignore open meeting laws, and again, students go after it, and you know it's hard to prove when they have a quorum, what they've talked about, so on. So that's always been and continues to be a problem with student media. Instructing faculty and staff to get approval to talk to a journalist. It's a university, it ought to be a place for open exchange of ideas, that sort of thing. But those orders come down. So that's always something that we've had to fight. And what's the other one? Okay, doesn't matter. More newish things, faculty being threatened with firing for being politically incorrect. So that can go different directions, but that's out there these days. Students having admissions revoked for social media posts deemed racist or sexist, fighting that. Students, like full-time journalists, are being targeted with tear gas and batons for covering protests, even when they're fully credentialed and cooperating with the police when they move the police line back. Recently in Seattle, student press members were subpoenaed for their notes, their photographs, their recordings at protests. This, of course, puts the students in danger, denies them the ability to function as journalists, and eventually the police gave up on that one, but they tried to push the students around on that one. So, you know, the enemy of the people, it's trickled down from the professional level to the student level. And so the students are aware of that, but I have to tell you that they're pretty up for it. They're in this for the right reasons. You know, but that does put the target on the backs of students. Who's going to talk to a student that's going to rat them out, you know, or identify them when they say they're not going to. And this just in, by the way, the president of Haskell Indian Nations University formally forbade a student from interviewing government agencies for the student newspaper. And he directed the student to start showing the highest respect for university administration, or else. So we'll see how that plays out, but I don't think the president's going to win on that one. So now to come from this from another direction, there is some truth to allegations of a cancel culture that we can throw back on our students a little bit. Sometimes I teach writing columns and op-eds, and in the last couple of years, I've noticed a trend in students just plain refusing to read our readings from classic columnists such as Jimmy Breslin, because he uses terms like dame and broad, and they don't want to hear these sexist terms. And it's like, come on, folks, you know, put it in perspective. But there's definitely a pushback there where they just don't want to hear it, for better or worse, and I think worse. Ann Coulter's been here, Robert Murray, the late Robert Murray. And when students protest that they should not have a forum, it's always a hassle for people like me, people like the provost, to say everybody gets a forum. Let them talk, then respond. So yelling over people is not appropriate, I don't think. And I don't think it serves what we are trying to do well, but that's where we are. There is some truth to that cancel culture thing. Here, literally, we had an ongoing kerfuffle about our priceless Thomas Hart Benton murals, because one mural showed the Ku Klux Klan in full regalia, and basically they ran Indiana in the 20s. And so that was all true. And in the corner of the mural was a reporter on a typewriter. So the whole message was that free speech beats hatred. But eventually, too many people said it was offensive. So they've changed access to that room where that mural is now. So it's too bad, because the whole message was lost in the image that some people found offensive. But the best story I can tell you about the current state of affairs, and it's here. Scroll here, sorry. Just a second, okay. And I'll preface it with Provost Robel's own words expressed to me prior to this session. And she said, in our system, the remedy for speech is speech, not censorship or firing people. It is speech, even if that speech is intellectually bankrupt. So permit me to read her statement from November 20 of last year, disseminated on the IU website and the student newspaper. It was a bit of an eye-opener. Professor Eric Rasmussen has for many years used his private social media accounts to disseminate his racist, sexist, and homophobic views. When I label his views this way, let me note the labels are not a close call, nor do his posts require careful parsing to reach these conclusions. He has posted, among many other things, the following pernicious and false stereotypes: that he believes women do not belong in the workplace, particularly not in academia, and that he believes most women would prefer to have a boss rather than be one, and he's used slurs in his posts about women. He said that gay men should not be permitted in academia either, because he believes they are either promiscuous and unable to avoid abusing students, etc., and that he believes that Black students generally are unqualified for attendance at elite institutions and are generally inferior to white students. This is Provost Robel. Ordinarily, I would not dignify these bigoted statements with repetition, but we need to confront exactly what we are dealing with the professor's posts. His expressed views are stunningly ignorant, more consistent with someone who lived in the 18th century than the 21st. Sometimes Professor Rasmussen explains his views as animated by his Christian faith, although Christ was neither a bigot nor did he use slurs. Indeed, he counseled avoiding judgments. Rhetorically speaking, Professor Rasmussen has demonstrated no difficulty in casting the first or lethal stone. His latest posts slurring women were picked up by a person with a heavily followed Twitter account, and various officials at Indiana University have been inundated in the last few days with demands that he be fired. We cannot, nor would we, fire Professor Rasmussen for his posts as a private citizen, as vile and stupid as they are, because the First Amendment of the United States Constitution forbids us from doing so. That is not a close call. Indiana University has a strong non-discrimination policy, and as an institution adheres to values that are opposite of Professor Rasmussen's expressed values. We demand tolerance and respect in the workplace and in the classroom, and if Professor Rasmussen acted upon his expressed views in the workplace to judge his students or colleagues on the basis of their gender, sexual orientation, or race to their detriment, such as in promotion and tenure decisions or in grading, he would be acting both illegally and in violation of our policies, and we would investigate and address those allegations according to our processes. Moreover, in my view, students who are women, gay, or of color could reasonably be concerned that someone with Professor Rasmussen's expressed prejudices and biases would not give them a fair shake in his classes, and that his expressed biases would affect his perceptions of their work. Given the strength and long-standing nature of his views, these concerns are reasonable. So in essence, she goes on to say that no student will be forced to take a class from Professor Rasmussen. The Kelley School of Business will provide alternatives to his classes. Professor Rasmussen will use double-blind grading on assignments. If there are components of grading that cannot be subject to a double-blind procedure, the school will have another faculty member ensure that the grades are not subject to his prejudices. If other steps are needed to protect our students or colleagues from bigoted actions, Indiana University will take them. So her point was, we respond to hate speech with more speech, hopefully not hate speech. And so I leave you with that thought that the solution to that speech is better and more speech. Thanks.
Thanks, Michael. Right, Tom?
Well, thanks, Steve, for the invitation to join this conversation this evening. And thanks to the National Society of Newspaper Columnists for drawing together an audience. And I'm going to abbreviate my remarks so that we can get a little time for Q&A at the end of this before our hour expires. Let me just say that I'm here on behalf of PEN America, P-E-N, as in mightier than the sword. It also stands for Poets, Essayists, and Novelists. We're a membership organization representing writers and editors and publishers. And we've broadened the aperture over the years to include screenwriters and bloggers and even ink-stained wretches, columnists. So you are all among our membership, and we advocate on your behalf in Washington. As an organization, we celebrate literature, we defend freedom of expression. Steve has asked me to, and so we've done a lot of research on a lot of issues in contemporary American society that affect free speech. Last fall, we published a report called Losing the News, which was a pretty detailed investigation of the demise of local news across the country, the disappearance of newspapers on an accelerating basis. There are different academic studies that say that over the last 15 years, one recent university study says 40% of journalist jobs in local newspapers have disappeared in the last 15 years. Another says 50% of local journalist positions have been eliminated. And there are a number of reasons for this related to technology, the way the marketplace works, social media, and so it's not one thing that has caused this disappearance of local news outlets across the country. But what's happened is that they've left a vacuum. And in the report that we published last fall, we postulated that local news historically in American democracy has been a building block of local democracy. It should be considered a public good, something that is not just another sector of the economy, another kind of business, but something that is important for connecting people at the local level to their neighbors and the level of government that affects them the most, local government and county government. With the disappearance of these news outlets, there's much less accountability and transparency in local governance. The numbers of FOIA requests, journalists asking for information from a government agency, have declined precipitously during these 15 years, especially at the local and the state level. They're still pretty robust at the federal level because major national organizations still have the capacity to pressure our federal agencies to try to disclose information and documents. But it's disappearing almost across the board at the local and state level. So we all know that nature abhors a vacuum. So with the disappearance of these local news outlets, two things have filled the space. One has been disinformation coming from abroad, as we saw in the 2016 elections and several rounds of elections since then, from Russia and increasingly from China and Iran and smaller actors, trying to fill the space with false stories, and especially on social media, which has become a vector for amplifying misinformation and disinformation in our society, as we learned from the Mueller investigation and other investigations. But what's completely domestically developed is what has been called pink slime journalism. These are websites, not so much newspapers, but websites that masquerade as local newspapers and pretend to be a local county or town newspaper. And they are created, there's some of them, and they're created mostly by political actors who are trying to push narratives about political campaigns, about political issues, about certain public personalities. But they don't subscribe to the usual precepts of journalism, which is that somebody says the mayor or the senator or the state representative is corrupt. You'd go to that person and ask, well, what's your response to this charge by your political opponent? These pink slime so-called news outlets don't do that. They don't do a fair investigation. They just print an assertion, publish an assertion, and they become vectors for propaganda and political narratives that may or may not be true, but they're essentially hired services for one interest or another. And so, and these are not mysterious, hard to find places. These are named corporations who own these sites, and they proliferate them across the country in various regions. Just last December, the Tow Center for Digital Journalism identified 450 sites, and subsequent analysis shows that the same companies have grown. One company has grown to encompass 1,200 sites across the country, pushing they're essentially fake news for hire. And any political interest that wants to pay them money will get a story generated and put on a website with a local seeming newspaper masthead. You know, the Lansing Daily Bugle, the Lake Placid Daily Reporter. They just put them online. They fill the space with false information and misleading narratives. There are some on the liberal and progressive side of the equation, but most of these sites work for conservative actors. And they are a reason for not only the disappearance of real local journalism, going to town council meetings and county council meetings and talking to the mayor and covering local events. That's not happening. It's just this assertion of false narratives pretending to be local news that is filling the space. So one of the things that we recommended in the report that we published last November was the creation of a federal advisory commission that would pull together a number of proposals to try to reinvigorate the economics of local news journalism. And the proposal that we developed has been introduced in the US Senate as a legislative proposal by Senator Brian Schatz, co-sponsored by Senator Amy Klobuchar and Michael Bennet. There's a discussion in the House about doing a similar version of the law there. Not a lot of things are going to get legislated and enacted between now and the end of this Congress. So these are kind of trial balloons that hopefully will be launched in the new Congress in January after the coming elections. Some people have said that this advisory commission is not necessary because there's been a lot of research and a lot of examination of what has caused the demise of local journalism. But I think the main purpose of a commission like this would be because it would be appointed by the four corners of Capitol Hill. Republicans and Democrats in the House and Senate would appoint people to this commission so that nobody would feel like it was captured by the other side. And if they were able to spend some quiet time together and with other experts, they might be able to come up with a package of solutions that could address the economic viability of local journalism across the country. Among the possible parts of this package would be tax credits to make it easier and more cost-effective for people to subscribe to newspapers, make it easier for newspapers to hire journalists, make it easier for the economics to work a little bit better. Another possibility is the creation of something akin to the Corporation for Public Broadcasting, which was launched back in the late 1960s in response to a prior generation's advisory commission, to create a public interest funding mechanism for local journalism of the print and digital variety. There's pros and cons to the way the Corporation for Public Broadcasting has worked over the decades. Some people don't like it, some people don't like it enough, but it has enabled educational and public interest broadcasting to exist, to be created on PBS, NPR. They're not mostly funded by the public funding, but the public funding has given them the kind of the startup funding to enable them to do the less partisan, the more disinterested, the more educational, the more public interest journalism that they broadcast every day. So that's one possibility that might come out of a commission like this. So that's pending on Capitol Hill. We continue to talk it up around both the House and Senate. And hopefully, if not remaining days of this fading Congress, maybe in the beginning of the next Congress, this might get some momentum. So that's among the things we're working on to address the problems of news deserts that have emerged and these ghost newspapers that are proliferating, to try to reinvigorate genuine local professional journalism. So back to you, Steve.
Okay, well, thanks everyone.